Hi. So we have some audience in the here, which is great. We separated this from the greater panel discussion, which is going to start at 3. So we're just going to get started now because this is all going to be recorded and posted to YouTube. So from now until 2:50, we're going to talk about the Unlock Bail Reform website and what we did with it this year and what our goals are for the next couple months. And then at 2:50 we'll break, and I'll just kind of put up a waiting screen, and then the panelists are going to join in, and then we'll restart at 3 for the panel discussion. So yeah, so thanks for joining us now, and we can get started. So my name is Avery. Hi, very nice to meet you. I'm a lawyer. I work at the John Howard Society of Canada, where I do advocacy campaigns to help break down the stigma of a criminal record. But I also have another hat, which is leading the Law and Design Collab. And what we do there is connect with creative professionals and have them work with justice advocates to make their messages more compelling and relatable. And I'll let Francesca introduce herself.
Hello, my name is Francesca. As you might see, I'm Italian, and I'm currently in Milan, actually. I've been a graphic designer for 7 years now, but I have a background in law, and it's my background and my current activity that brought me to join the Law and Design Collab almost 4 years ago, I'd say now. I've lived in Toronto for 4 years, and I just moved back. That's the reason. I lead designers at the Law and Design Collab, and I liaise between the design team and developers to bring our projects to life.
Okay, great. Thanks, Francesca. So I'm going to start off by sharing my screen because I can't assume of the audience that you've seen our website already. So I'm going to walk you through kind of what it looks like, what we did last year, and then how it's changed since then. So let me just open this up. Okay. Here we go. Okay, so this is, pressed the wrong button. Sorry about that. This is the current version of the Unlock Bail Reform website. This is what we launched last year at this time for Access to Justice Week. And you can actually go visit it live now and explore around. The thinking behind this website, and I guess behind our whole work altogether, is that bail reform is an issue that, in some senses, has been studied to death. The reports and research that's come out have very clearly diagnosed the problem and recommended, clear actions. But there's been just so much political inertia. Even the courts, hand down several, very large decisions, the Supreme Court as well as the, a Superior Court, and still we're not really seeing the change that's needed. And this is really something that only government can do. So our hypothesis is, why is this not making an impact? Maybe this information is not accessible enough to people. It's not made in a way that's interesting and compelling. So what we did with this site is we kind of took the research and we turned it into several different user interfaces. So we started out with this idea of mapping out the systems, kind of who are the main players, what are the different stages of bail? So we kind of set this out visually, and kind of what goes wrong. So that was one UI. A second UI was kind of talking about the human stories, like what is the human cost, trying to humanize this issue. So we kind of had a little storytelling UI like this, and if you keep scrolling, there's three different stories there. And then the third UI that we worked on was this idea of an explainer. So, I think these are a lot more common now. You'll see them a lot on websites like Vox, but even I think National Post has some good explainers. And the idea here is that we guide users through the cause and effect, which is, for this issue, can be a little complicated and convoluted. And then lastly, we wanted to show that there's been so much work and in some sense like a consensus, at least in the expert community, about what needs to be done. So this is kind of all the research that we thought. That this is a curated list. There is of course quite a bit more research for people to get up to speed. Okay, so I think that kind of recaps the site as it was last year. And so before I pass it off to Francesca, I'll just talk about some of the main considerations that we took into account. So first of all, like this site, even though it's we experimented with different UIs, it's still an overwhelming amount of information and such an in-depth level of information that an everyday person it's really not accessible to them. So we are actually working with a lot of professionals or volunteers who are professionals in advertising agencies. And I didn't think in my career as a lawyer I would work with advertising agencies, but the skill set is really, really important. And what we did is we just slimmed down the entire site and we identified our very specific target user. So target user 1 is someone who has no idea what bail is. They will probably only be on our site for 30 to 60 seconds. Like what do we have? What are we going to deliver to that person? And then person 2, who's probably our larger target, is somebody who cares about these issues but doesn't understand bail very much. But they want to, and they want to take some type of proactive stance. So the time that we're trying to optimize is around 5 minutes of interaction with them. What can we achieve? So with that, I'll pass it on to Francesca, who will kind of walk through the main concept, and then I'll recap again. We'll talk about the strategy and why we think this is a promising strategy, given all the other type of work that's been done. Okay, I'll stop my share here.
Yeah, and I will start sharing mine. Are you seeing my screen?
Yep, looks good.
Okay, so taking it back exactly where you left off, once we came up with these 3 personas, we came up with also one flow for each of them. And what we decided as, and also a main difference from the previous version.
Oh, hold on a second. Sorry about that. I'm seeing a cut signal. Francesca's frozen in my account. I'm going to see if I can reach her right now.
Okay.
Oh, sorry, you cut out for a little bit. But as soon as you open the persona 1 and 2, it cut out. So.
I'm sorry.
No, it's not your fault.
Am I back?
You're back. I'm going to try turning off my video, and maybe that might make a difference.
Okay. Well, I will turn off my video as well and keep the screen only.
Okay, great.
Are you seeing my screen?
Yeah, it's working now.
Okay, cool. Sorry. So taking it back, we came up with 3 different flows. It's a mobile-first approach, which means that people will be able to browse the website much more easily, even outside of their house, without having to sit like if it was something that they have to study in a way. So what we did is we came up with 3 different paths that they can follow with the components that we have in our website, which are a landing page that provides a very quick and easy overview of the issue, and I will show it to you here. So you can see by scrolling, you can have very impactful statements and facts and stats, something that can also have a teasing effect on an audience that doesn't know anything about bail or not a lot about it. And then once you get to the end of it, you can decide whether you want a very, very quick experience. And so you go to the what can I do? You want to have a more action-oriented approach, and you go to the resources page where you can find out more and read more materials about the topic. You can find ways to support others. You can spread the word, so we will provide ways to share stuff and share other materials, or you can get involved. And this is the very, very quick experience on our website. Then, as Avery was mentioning before, you can have a more in-depth kind of experience. And so you can go, sorry, guys.
I think you just have to minimize it, Francesca.
Yeah, sorry. So you can go, sorry, I will be there in a sec. It's a long time. Okay, you can go to the system map. I don't know why it's not working. Sorry.
That's okay.
Okay.
Oh, here we go.
Yeah. There it is. Okay. This is our core functionality where we provide the more in-depth kind of information. We provide 2 levels of information at a first glance, so you can check out how the current situation is, and you can keep the toggle here and just scroll through these 6 cards. We divided our content in 6 steps, basically, with this card-based approach, which means that you can have a very quick overview for each of the steps. And if you want to know more, you can just click and read more. And here you have a deeper level of information, still in very quick statements, quick bullet points. Again, we want for people to get the most of it without having to study, you know. And then if you want, you can flip the card basically and read about what it could be. So a what if kind of approach. And that's also the reason why we have 2 different colors for a more immediate kind of feeling in this sense. And the same you can have here. So you can toggle back and forth between these 2 statuses and see what is and what if, basically. This idea is that we progressively disclose more and more information only to the people who are interested to a deeper level of information. You can also just stay here and do it quickly and then get to the resources if you want. One more feature that we plan to have together with these 6 steps is the root causes. So the root causes are something that are related to the bail reform, in a sense that bail reform doesn't only refer to criminal law. It's something that impacts people's lives in a very in a more general way, and a bail reform could impact different aspects. And maybe Avery, if you want, you can talk more about that.
Yeah. Yeah, I can just jump in very quickly. So yeah, I mean, one main difference between the previous site and this one is actually that we're working now with a professional developer, and because before we were just using pure volunteer labor. So one of the things that you're not really seeing in this Figma, as opposed to the final product, is the animations. So what we're hoping to achieve is that as you kind of come to the end of this system map, basically the background, basically what we want to try to convey is that these problems with the bail system are in fact a symptom of much deeper problems of overusing and misusing the criminal justice system. So these root causes are, these are like the socioeconomic determinants of crime. So we have like poverty, homelessness, addiction, mental health, systemic racism, and legacy of colonialism. And these are kind of the core things that we need to address. So while fixing the bail system is important, these are kind of the things that are driving a lot of the problems. Yeah,
and we plan to convey visually as much as possible in the actual website. Of course, a Figma prototype has its limits, that's for sure. So as I was saying, we progressively disclose different levels of information. And one more thing that we plan to have is an even more in-depth kind of approach with a long essay version of the content. It's not going to be part of the first MVP that we will release, but we plan to have that as well for a more professional kind of audience that maybe knows already a bit about bail, or after they go through the whole experience, they want to go more in depth.
Yeah, I think the idea behind the long essay will be that it's kind of more like a long form journalism, essentially. So it's still, the writing is still going to be very accessible, but it's going to go to a deeper level than we could do with this interface.
Yeah.
Okay, great. So Francesca, if you go back to the actions items, I just want to speak to a little bit about the strategy and what we're hoping people will do.
Yeah.
Okay, so I guess I can turn my video back on. here. And also, I just want to keep track of time so we don't run over. Okay, and we have another 5 minutes. Okay, so yeah, I mean, I think what we, you know, again, we're really focusing on people who are really not familiar with the bail system, and I think that's the right thing to do for a couple reasons. So one is that a lot of the law reform efforts have been very disappointing in terms of what's been achieved. So when the Liberals had a majority government, there was a bill that was passed to reform bail, but it really was not very effective at reforming. It was, I don't even know if we could call it the bare minimum, but it did not achieve any of the goals that the literature had and advocates had been pushing for. You know, the political positions of the parties is nobody's really advocating for criminal justice reform. It is not an issue. It is not an issue that's well supported by the public. So why would politicians take the risk of doing that? So there's definitely some rationality on their part, but I think that just kind of goes to show, like, you know, we really need to have a more concerted effort at educating the public and making them care about these core issues. And I think, you know, now more than before, over the last, you know, since COVID, and we had, you know, lots of protests and calling attention to history of, you know, ongoing problems with colonialism and racism, people are interested in learning these things. And as an example, so during the protests in 2020, there was a bail fund that popped up in Canada, and it raised, I think, like over $100,000 in a week or so. And so if you're an expert on this issue, you'll know that we don't have cash bail in Canada. So it's kind of interesting to see that, you know, even among people who really care about this issue, or could be the people that care about this issue, there's some really deep-seated misconceptions, you know, taking US ideas and concepts and just applying it to our context without kind of understanding the nuance that's needed. So that's kind of one key part of the strategy. I'm going to pass it back to Francesca for a second to kind of talk about, you know, how we modeled this approach. Oh, Francesca, you might be muted.
Yeah, I wasn't finding the button actually. Yeah, so let me stop sharing this screen and go back to my other screen for a sec. Are you seeing it?
Yeah.
Okay, cool. So there were actually a lot of very inspiring projects that we saw throughout the months that we worked at this, most of them based in the US, I'd say, on various topics when it comes to law and especially criminal law. But what we took away as an inspiration mainly was their high level of interactivity. So, and also a very quick and easy way to provide meaningful information. So as you can see here, again, quick statements, the hierarchy of information, pictures, very visual. And then one more thing that we saw was recurring was the possibility for people to, and let me get there, see more and go deeper, and then to have resources to take away. And another example is, for example, this, very emotional. It's a story, COVID-related story of a woman who tried to save her inmate husband from getting COVID, and unluckily he died from it in jail. You have videos, so a lot of use of media, something that people can quickly get information from, and also relate to in a way. Again, related news and information, very cool graphic, and a call to action at the very beginning, because what we realized compared to the previous version that we worked on was that people sometimes want to go directly to the to the action, directly to where they can do their part and give their contribute. Sorry for the background noise. Another example, very wide example, this one, Motion for Justice, again, US based. Similar to us, they have a history page, so a lot of information and text. And then they have text that people can read to go deeper, values, so a quicker approach divided in topics and subtopics, media, you see, and resources, and again, action steps, because it's as we realize, it's something that people want to get quickly to. Avery, I'll give it back to you.
Thanks.
To see that we are.
Yeah, we're at time. Okay, well, yeah, thanks everyone. I would just encourage everyone to follow us on social media. We will be announcing when that full dev version of the site is up. And also we have a really amazing event that we held yesterday with kind of leading journalists covering criminal justice in Canada. Super insightful. So please follow us on social media to get those announcements. And I guess the very last thing to conclude this overall project, like, you know, some of the things that you saw from Francesca, there's many other examples in the US. And I think it's you know, it's a big deal there, not just because their criminal justice system is like a global aberration, but there's also been a huge amount of philanthropy and investment in communicating these issues. And I feel like we just can't say the same about that in Canada. And hopefully, you know, this site and our work last year can make a stronger business case to philanthropies and other organizations who want to fund the work. Okay, thanks very much, everyone.
Thanks, everybody.
Okay, thanks, Francesca. See you later.
Bye.
We're going to transition now to just setting up the panel. So we're just going to do some tech checks, and then we'll reconvene at 3 o'clock. Okay, one moment. Okay, let's get started then. Thank you, panelists, for joining us, and thank you to the audience. We have 40 people who have tuned in late on a Friday afternoon, so we really appreciate you all coming out and giving your time. My name is Avery. I'm a lawyer. I work at the John Howard Society of Canada, where I do advocacy work to help break down the stigma of criminal records. But the other hat that I wear is at the Law and Design Collab, which is a nonprofit that connects creative professionals with justice advocates to try helping make their work more impactful. So I'm delighted to be here. This is why be optimistic about bail reform? And this is more of a provocative question. I didn't mean to be Pollyannish, but we'll definitely see how these expert panelists field that. And this is part of A to J Week at the Law Society of Ontario. So for those of you who kind of came to us through social media, I would encourage you to check out the Law Society's website. You can see a lot of events, and I think a lot of recorded events from this week will be posted. And I want to have a special thank you to Nzinga, Winna, and Sheena, for making this event possible with their support. Okay, great. So we're going to start off. Oh yeah, sorry. One more thing to measure. You may notice that Ian is not Promise. So Ian McQuaig is a lawyer, and Ian, I'll let you give your intro actually shortly. But I just want to say Promise had to drop out last minute due to a family emergency. So we're really happy that Ian could step up, who has a real depth of experience to share with us. Okay, so we're going to start with by having each of the panelists speak for about 5 to 7 minutes about their work and answering kind of the key questions that you all saw on the Eventbrite. And then we're going to switch to a moderated discussion and then take audience questions while we do that. Okay, great. So to kick things off, let's turn it over to Danny. And oh yeah, and if you just have a quick one-line intro as well, Danny, that would be great.
Thanks, Avery. My name is Danny Morton. I am counsel with the Indigenous Justice Division at the Ministry of Attorney General. My background is Japanese and Irish, but I have been fortunate to work with Indigenous communities within the justice system for now over about 15, over 15 years in any event. And so I did prepare a slide deck. I'll try to share it here if it does work. Here we go. Hopefully folks can see that. Can everyone see that?
Sorry. Yes, looks great.
Great. Okay. So, you know, as I mentioned, I work with the Indigenous Justice Division, and so I will be speaking mostly, you know, with respect to how this question applies to Indigenous people involved in the justice system. You know, it is a difficult question. It is a provocative one. How optimistic can we be? I'm not really sure. I think it's important to set the stage in terms of where we're at now before we start looking forward to the future. So we know Indigenous people are overrepresented throughout the justice system, you know, in custody and otherwise. Most of the attention here has focused, you know, previously on overrepresentation rates on sentence. And we know that, in fact, the largest overrepresentation of Indigenous people is, in fact, at the bail stage. I don't think it's an overstatement to say that there is no other process within the justice system that prejudices and discriminates more against Indigenous people than the bail stage. And so on this slide, we can see that in 2018-19, although Indigenous people only represented about 2% of the general population, they represented 10.6% of admissions to provincial institutions on sentence, which is, you know, a shocking overrepresentation. But as I indicated, you know, the overrepresentation rate is in fact higher at bail. So an admission on remand means that the accused person has gone to jail because they cannot be released on bail. And here we see the overrepresentation rate being almost 14%. Another way to look at this is today, or at least in 2018-19, over 2/3 of all Indigenous people in provincial institutions were there because of bail, because of the fact they could not be released or were not released on bail, still being presumed innocent, still, you know, not having a trial, just simply because of the barriers that Indigenous people face on bail. Similarly, this graph just demonstrates the trend, and what's significant here is if we go back to 2000, that's when stats began to be kept on Indigenous identity when people were admitted into custody. This was in part as a result of the Supreme Court of Canada case in Gladue, which was the court's first opportunity to assess recent amendments to the criminal code that required sentencing judges to consider the unique circumstances of Indigenous people. And what is troubling here is we see that even though the Supreme Court of Canada came up with a different analysis for Indigenous people, directed judges that they absolutely must apply it in sentencing, and directed judges that they should be trying to remedy the situation of overrepresentation, what we see is that since 2000, the numbers have continued to climb. Right? And the blue line here is admissions on sentence. The orange line here is admissions on remand. Now, Ontario is one of the only provinces where we actually see in recent years a slight decrease in overrepresentation rates on sentence. My opinion on that is that's largely attributed to the fact that we have a significant Gladue report program in Ontario, and I think that is being effective. But what is troubling here is that we see the overrepresentation rates for admissions on remand continue to climb, and although these numbers are somewhat dated, this trend continues. Generally speaking, and this is just a very high level overview, Indigenous people are detained at a much higher rate than non-Indigenous people. If they are released, they will spend more time in custody awaiting bail. If they are released, they will have more conditions imposed, will have more invasive and onerous conditions, and are more likely to require supervision either by a surety or by a bail program. Indigenous people are more likely to be charged with breaching bail, are more likely, and this is previously, were more likely to be denied by bail programs. Indigenous people are more likely to endure greater hardship as a result of either being released on bail because of the conditions or as a result of being detained. And as if an Indigenous person is putting themselves forward as a surety, they are more likely to be rejected by the court as being suitable. This is just speaking generally about Indigenous people across the province, but as you can see here, this is a map of Northern Ontario. What you see on the map is takes up more than 2/3 of the province. It's actually quite a bit more. And what you can see in the center at the bottom there is Thunder Bay, just as a point of reference. And so there are a number of unique barriers for Indigenous people in northern remote communities. If an Indigenous person is arrested anywhere in the province, they have to be removed from their community. If they're living in a First Nation, removed from their community just for the purposes of bail. At the very top of your screen, you see Fort Severn there. And so, basically the way the process works is if an officer is not prepared to release on a police undertaking and the Crown is not prepared to release on consent, so a contested hearing is needed. Generally speaking, people are flown out just to have that hearing. And Fort Severn is 825 kilometers away. And so as you can imagine, that person is flown to Kenora, where they will have a bail hearing. And if they are released, they will essentially be rendered homeless. There previously was very little assistance to get them home. There is all sorts of other barriers and challenges that result from that. Now, as a result, when we look at overrepresentation rates in the North, they are significantly higher than anywhere else, as are remand rates. And so the Kenora jail, for example, is 90% Indigenous and 90% of the inmates are there on remand, meaning, again, they are still presumed innocent, have not been proven guilty. They simply cannot meet the requirements of bail. And I'm going to go through some of this relatively quick. I don't want to take up too much time. So I think, these slides just represent the fact that Indigenous people are overrepresented when it comes to being charged with fail to comply charges. And I won't go into detail again just because of time, but it's significant to know that most of the breaches, the vast majority of breaches, are technical in nature, meaning it is things like abstain from alcohol conditions, breach of curfew conditions, do not associate conditions. Very, very few of the charges laid are in fact substantive charges, people committing new offenses. And just mindful of the time, I'm going to skip over a few of these because I do want to touch on 3 programs that the Indigenous Justice Division funds. Starting in 2017, we began funding Indigenous bail verification and supervision programs. These programs provide community-based supervision in the community. They are designed, developed, and delivered by Indigenous organizations. And there are currently about 24 programs in the province, a number of which are in remote fly-in communities or northern remote communities. And so again, these programs are very effective in providing supports fundamentally, but also supervision and enforcement for Indigenous people who otherwise would not be released on bail. We also, the Indigenous Justice Division at MAG also funds 4 Indigenous bail bed programs. These programs provide an enhanced level of supervision as well as accommodation and support to individuals who are probably at a higher level of risk, but more fundamentally are in a position where they're at the intersection of criminal justice and homelessness. And a lot of that has to do with the displacement of people from the North. So as I mentioned, somebody from Fort Severn or any northern community will be displaced for the purposes of bail. And if they find themselves in a place like Kenora, they are going to be very far from home. And so they will need, additional supports. Lastly, we fund 2 Indigenous discharge planning programs. Prior to the existence of these programs, when somebody was displaced from their community for the purposes of bail, there was virtually no assistance in getting them back home. And so the justice system removes somebody by force from their community with police escort in custody, releases them in a place like Kenora or Timmins, and then doesn't provide support to get these individuals home. And so these programs have been operating since just before COVID in any event, and they have been absolutely integral during COVID, not just for arranging and paying for people to get back home, but also coordinating with chief and counsel in communities to ensure that COVID protocols are being followed, ensuring clients are able to obtain, the property from jail, medication, clothing, anything else that they might need. And of course, it's significant that these are all Indigenous organizations providing this service. And so NAN Legal helped about 300 people get home in the last year, and Grand Council Treaty 3 has helped about 200 people get home. So very essential programs. I think I've gone over my 7 minutes, so I'll stop there. Thank you.
Great. Thank you so much, Danny. And we'll definitely build on some of these topics and themes that you've introduced. Okay, so I'm going to hand it off to Ian. Ian, if you want to give a quick intro about yourself, and then, yeah.
Thanks. Well, to start with, I'm not Promise. So sorry to disappoint. I'm a criminal defense lawyer. My office is in Toronto. But right from the beginning of my practice, I was lucky enough to get some clients out in Six Nations, been working there pretty steadily for the past 5 or 6 years. And by far, I think that's the best part of my practice. I do a lot of legal aid work, and I do an extraordinary number of bail hearings. That is the one thing that probably makes me different than a lot of counsel. Rather than that was a bit of a bummer what Danny just told us. I think I have a slightly different perspective in that there is a reason to be optimistic about bail reform. There's a bunch of reasons, which is not to say that there aren't tons of problems, but there's lots of reasons. The law is getting better. The Supreme Court, they started their leadership, probably 30 years ago. But in the last few years, we've seen ANTIC, where they talked about the bail ladder and restraint in bail conditions. They doubled down on that in Zora. They told us in Myers that we can't just ignore 525 reviews and that we have to get them done. And if people can be released, get them released. Justice DeLuca and Tunney gave us some guidance about sort of expediting bail hearings and bifurcated hearings and talking about releasability before we talk about the plan. Justice Doherty and Jasser gave a lot of really helpful comments about sureties, about how to analyze the secondary ground. So there's some leadership. The other leadership, which is kind of more invisible, but you see it if you do a lot of bail hearings, is the quality of our JPs is just steadily getting better. They're more knowledgeable. They're more willing to consider unconventional bail plans to assess risk and release clients. I've been having steadily more and more success over the last 5 or 6 years. Defense lawyers, I think, are getting better as we get more educated. I started out at a time, I think, just when the bail system started to move a little bit. And I kept doing all these bail hearings for colleagues of mine who are a little more experienced. And they would say, oh, this is hopeless. Here, go to this hopeless bail hearing. And I would come back with a release. And they were always shocked. And I think now we're starting to see the tide turn where we expect to get our clients out. Initially, I was going to say that COVID actually hadn't improved the situation. But I was thinking about it, and there's 2 ways that COVID has improved the situation. One, bails by Zoom are just so much better than having everybody have to drive. This wacky plan they have in Toronto, or had in Toronto, I don't know if it's going forward, or everyone is going to have to go to 2201 for bails. Hopefully that dies and we just get to do Zoom bail court. Sureties shouldn't have to drive 2 or 3 hours or take transit 2 or 3 hours to get to a bail hearing and then find out that the bail hearing doesn't get reached because the court's too busy that day and take another day off and another day off and another day off. I think Zoom bail hearings, telephone bail hearings, big improvement. I hope they stick around. And the other thing is the death of the special or lengthy bail hearing, and they're not quite dead yet. But the directive that came out to say, Crown stop reading allegations for 3.5 hours at the start of a bail hearing and just file a bunch of documents so that we can get these things scheduled in 2 or 3 hours instead of 2 or 3 days. These are improvements, and I think they're making bail more fair. They're making bail easier to litigate. There was a magical time at College Park where judges were doing bails. And that was amazing because the bail list I never saw anyone get remanded off the bail list who had a bail plan when judges were doing bails. They got reached, and if there was a plan, they got released. Crowns seem to be more reasonable when looking at a red sash. That's the only explanation I had for that. Unfortunately, that pilot project ended. There's still some challenges. The big ones, A lot of our crowns have responded very positively to the leadership from the court, to the changes in legislation, but not enough of them. I still get crowns tell me their position is a detention order. And I say to them, are you seriously telling me that no surety with no plan could possibly supervise this accused person? And most crowns will then reconsider and say, oh yeah, you're right, release to a suitable surety. And that changes the nature of the litigation because you don't have to go into court and argue about releasability. That shortens the bail hearing, and it means that somebody can get reached and possibly get released. So there's work to do there, educating crowns. The big thing, and I think this is Danny kind of addressed it, is there's still a very white middle class conception of what a release plan looks like. And we have to learn to reach out into the community to find resources that poor people, that people from different ethnic communities, their family structures, their living arrangements. Not everyone has a mom with a basement where they can move in and have a residential surety, and not every surety needs to be a residential surety. So that's one of the big challenges, is just to change that conception and recognize that we live in a diverse society. I have no idea how much time I've used and when I should stop talking. Someone should remind me.
Yeah, we should wrap up just around now.
Okay, well, that's fine. I'll leave it at that.
Okay, thank you, Ian, for sharing your perspectives. That's really great. Okay, I'm going to pass the floor on to Farida.
Hi, everybody. My name is Farida Adam. I am a staff lawyer at the Black Legal Action Center. The Black Legal Action Center is a relatively new legal clinic in the clinic system, and our mandate is to combat anti-Black racism within the province of Ontario. Prior to my role as staff lawyer at the Black Legal Action Center, I was duty counsel. So I come to this conversation a bit different. Bails are considered the bread and butter of duty counsels across the province. I worked primarily in Brampton, one of the busiest jurisdictions in this province. And I did a good mix of adult bails and youth bails, primarily a lot of youth bails. I too think that this question is, it's not an easy question to ask. Are you optimistic about bail and bail reform? And I think I am. And I started doing bail hearings in a post-Antic world. And when Antic came around, Antic was really exciting, I think, to a lot of duty counsel and a lot of those of us who work for legal aid or work in the clinic system, in the sense that Antic clarified what we already knew about bail, which is that bail is a ladder. And furthermore, an undertaking without conditions is the default position for a bail hearing or bail plan, which I think was hard to stomach to a lot of JPs and judges sometimes when you're making these submissions before them. Surety releases tend to be the default. And I think Ian mentioned Tunney. In Tunney, Justice DeLuca talked a lot about this, right? There is a comfort in surety. You have an accused person before you. That accused person is charged with potentially difficult, some people may perceive heinous crimes. And it's very tempting to believe that this person or this individual is requires supervision by an individual, oftentimes a residential surety, somebody who can watch and make sure that they comply with their bail. But that doesn't fall within what Antic tells us and what Antic has clarified about what bail looks like when we look at the rule of law. So for me, I was really optimistic, and it's really nice actually making submissions when you have a Supreme Court of Canada case and you're telling Justice of the Peace is that no, this isn't really a matter of opinion. This is not a guideline. This is not even a suggestion. This is the rule of law. I think the difficulty that came with Antic and Tunney and some of the clarifications about bail being a ladder and that we have this culture to overly rely on sureties is that you relied on the advocate, so the person running the bail hearing. There are lots of defense counsel who don't, in fact, run bail hearings and rely on duty counsel. There are some lawyers, obviously, criminal defense lawyers who do come in and conduct bail hearings, but a lot of times that's duty counsel. So then you have to think about the circumstance that duty counsel is in. So duty counsel often has a number of people to deal with. Often there's limited time to get instructions or speak to the individual in cells. Ideally, you would have your colleagues go speak to that person and get that information. But ultimately, some things fall through the cracks. What I really appreciated about ANTIC was that it's not just about talking about bail and the fact that an accused person is entitled to reasonable bail, but more so, what are the conditions of bail? And that's where I think a lot of the promising work has been happening. Sometimes we focus on, the Crown position is detention or release, but when the Crown is consenting to the release, what are the conditions that they're seeking? And do those conditions not only have a nexus to the allegations and the offense, but what do those conditions do to the individual? Do they set the individual up for failure? And I'm sure we'll get into this, but in particular in youth bails, some conditions that you would see in bails that are deeply problematic follow the rules of the household. Sometimes there would be curfews or house arrests. Again, not necessarily because there was a nexus between those conditions and the behavior of the young person, but rather bail court or youth bail court was attempting to step in to substitute itself with social measures. So the young person is in need of supervision, shouldn't be out past 9 p.m. So that's why, maybe the curfew is appropriate. But we're in criminal court, and in criminal court, you can't substitute the rule of law with a sort of personal assessment or belief that the youth is in need of additional supervision. I mean, that's a separate issue. And so a lot of the time that I spent in court making submissions about bail were about the conditions. And unfortunately, you would hope that if a Crown were to consent to a bail or consent to a release, that it would sort of make the process a bit quicker, but I found sometimes that wasn't the case. In fact, it would make the process longer, especially if you were debating the Crown in terms of what conditions ought to be or ought not to be on the bail. So I think from my perspective, especially transitioning to Black and thinking about how criminal law intersects with other areas of law, like housing, like social assistance, employment, you have to think about the individual holistically. And so when we think about all the data, the plethora of data that we have about the overrepresentation of Black people in provincial facilities and in federal facilities, we think about the Ontario Human Rights Commission report that says that a Black person is exponentially more likely to be subject to overt use of force. It begs the question, and hopefully ANTIC encourages us as we're doing this work to think of the client as holistically. So you don't want to consent to conditions that potentially will impact other aspects and areas of that individual's life, especially what we know about the racialization of poverty, more broadly speaking. So am I optimistic? Yes. Do I think that there are areas that we need to explore? Absolutely. One of the primary areas that I hope that we explore, based on the system that we have and the fact that we rely a lot on duty counsel and legal aid to fund criminal law matters and to offer assistance to individuals, is the oversight mechanism. So if you're making submissions on a bail and your duty counsel and the JP or whomever is not really willing to hear your arguments, well, what mechanism do we have to review that decision and to hold that decision maker accountable for their failure to follow the law? We rely a lot on bail reviews, and bail reviews are pretty hard to get. In youth court, it's a bail de novo. It's a bit of a different process, but it's pretty hard to get a bail review, especially when you don't have a private lawyer and you're relying on duty counsel. And so I would hope that, and maybe we can explore this as we continue to talk, but that we pour more resources into the accountability mechanisms available to us. How do we review these decisions and sort of ensure that, especially those of us who come and represent vulnerable communities, are not having our clients subjected to onerous conditions that really will set them up for future failure and this persistent cycle and involvement within the criminal justice system. I don't know if,
yeah, that's great. Thank you, thank you, Farida. Yeah, lots of things to keep exploring. But let's pass it to Cassandra now to provide her take.
Hi, everyone. So I'm Cassandra DeMello. I am counsel in London, Ontario. I did my work in my master's on the issue specifically of bail and mental health. And I'm currently back at Western for my PhD, but it's on a slightly different topic. I consider drug addiction issues to be part of the umbrella of mental health, but it's more on drug addictions now, what my focus is. But I pull a lot of my comments from my own work on bail and mental health from my master's, but then also from my practice. I run a very busy practice here in London. We have a few associates, and between the four of us, the four lawyers at my office, we're probably running on average 5 to 10 bail hearings a week. So we've got a good number of bail hearings, but I also at one point want to touch on bail reviews, because I think that that's a lost opportunity that a lot of counsel just don't know enough about, or perhaps are afraid to bring more often. So I will touch on those too, and how there's some positive change there as well in the law. So the first thing I want to do is I'm going to put in the chat the actual website link to the Chief Justice's directive on how to do bails better during COVID-19. And this is, I think, something that I know Ian mentioned already briefly, and really it's full of little nuggets that you can use when you're talking about bail and when you're live in the trenches trying to figure out bail. I can tell you firsthand that we are constantly getting pushback from Crowns, basically just not wanting to do their job. They want to put things over for a day or two at a time in London. It's quite common. Same of the smaller jurisdictions around London that we practice in. They don't seem to see the value or the importance of same-day bail, which is really, really frustrating, given that our directive now says that for sure. But then you've got recent cases like Regina and Simonelli, where if you're not getting a bail hearing within 3 clear days, then your client probably has a stay coming their way if you can show a similar record to Simonelli. And so it kind of boggles the mind that in light of Simonelli, there is still so much dragging of heels to get clients to bail when it's their charter protected right. And it can really be infuriating. But the way I have approached this always is to approach it from a position of advocacy for sure, where I'm basically pointing out how ridiculous the position is, but based in a principled law. So I either point them to the Chief Justice's directive, because you'd be surprised how many Crowns haven't read it. And so basically just reminding them that they don't need to read in the facts, as Ian pointed out, or even encouraging them not to have to cross-examine your sureties. That's a big piece that the culture shift has not happened yet, where Crowns are still wanting to constantly sit there and cross-examine sureties for 20, 30 minutes at a time. It's a colossal waste of time. The question is about whether or not the plan is sufficient. And you don't need to know, how they're going to be watching their cell phone at every moment of the day in order to know whether or not the person's cognizant of their role and more or less able to fulfill it, right? So I always encourage people to read and quote from the Chief Justice's directive, because it's the most recent pronouncement on the issue, and it's a very recent reminder of how bail courts are supposed to be running, especially in smaller jurisdictions like mine, where the 20-minute bail hearing was never a thing. Each bail hearing was always an hour or more, and it's gotten quite out of hand. To talk about Zoom bails just for a second, there's benefits for sure, and especially if you practice in Toronto like Ian, I could see why there's benefits to perhaps avoiding this issue of the super court downtown and the access to justice issues that's going to raise. Certainly there's been an access to justice in terms of sureties being able to connect with the court via Zoom or teleconference. But the biggest drawback, and I know we're not really wanting to focus on the drawbacks, but it's worth mentioning, the biggest drawback of Zoom bails is the inability for us to really connect and meaningfully talk with our clients about the bail plan and to put things into works in a very dynamic situation. So you've got, for example, a client that says, call this surety, call that surety, and if you don't get a hold of them, maybe I can think of some other people. So you go call those two numbers, there's no answer. And then you could just run back to cells before and go get more phone numbers if you needed to. Or even the simple task of getting your client's cell phone in your hand so that you can scroll through their cell phone yourself and look for the numbers when otherwise they're not going to have access to that. Those types of things that, were already difficult enough before have just really become way more difficult now in COVID world. And so the inability to be directly able to see my client or talk to my client in person is, I think, the biggest shame of all of this. And so I'm not saying that we need to move back to a fully in-person model, but on Ian's point, I think it would be nice to have some sort of option for, sureties can call in, but counsel can go and see their lawyer if they want to, right? So the client should be down at the courthouse, and then if the lawyer wants to Zoom in, then great. But if they want to go down and see their client because it's one of those touch and go bail plans, then they have that option too. I agree with the comments made so far about, the promise that Tunney has given us, that Antic has given us. And we've seen this kind of picked up on in more recent cases, Tunney and Zora, that have been offered up as starting points. What I will say is that Tunney is an important decision to take a look at, because when you have a Crown that's basically saying either detention is necessary or maybe it needs a surety, but you don't have a surety, there's almost this ability to do this bifurcated hearing where you can determine whether or not a surety is even necessary and then go on to whether another plan would be necessary. And I think we forget about that option. So many of us just go right into a full-fledged bail hearing where it might not even be necessary to do that. So take a look at Tunney. It's got some really great points there. And what I want to now focus on for the last few minutes of my time is the mental health component of bail. So many of our clients, almost regardless of what area you try to specialize in, are going to be touched by mental health issues. And so what we need to be cognizant of is the fact that our system does a really, really poor job of setting up supports for people with mental health issues at the front end. Even at the back end, I'm not sure we do a good job. So for example, I'm talking about sentencing, right? Probation report as directed to your counselor and do whatever counseling they say. Great, maybe hopefully that will be something that the person needs and can benefit from. But more often, and this is what my master's thesis focused on, is, what about the front end? What about those clients that you have that are begging for help? They don't know who to turn to, they don't have resources, and you're in cells with them or you're on the phone with them, and they don't have anybody to come and support them. They barely have any contact with CMHA even, or your local mental health workers. And then it really just becomes almost overwhelming, even as counsel experience with people with mental health issues, to try and figure out a plan. And I find those ones are the hardest sometimes too to convince Crown to release on consent, or for a JP sometimes to release on if it is a contested bail hearing, because people get really afraid around mental health issues. If the synopsis reads at all like there's a mental health issue, it's almost like the social control aspect of like, well, they're safer in jail. There's, they're less, it's less unclear what they could get up to if they're in jail, and, community's almost safer there, because we still have the stigma around mental health that it immediately means danger. And it, as we know, it doesn't. But it's really hard as counsel to push back against some of those notions, right? And even if you are securing a bail release for your mentally ill client, what Farida was saying about, the terms and being very cognizant of the terms, that's equally important for your mentally ill client. If you've got a client who is not very good with appointments, for example, is John Howard Society really the best bail supervision program for them if they're going to need them to go in and check in once a week in person, right? Maybe a telephone call is sufficient. Maybe it can be that they are required to check in by telephone only, so that at least there's a shot of them making their appointment. Or maybe it's that that's just not the right program at all, and we need to explain to the JP why they're more likely to be able to comply with their own recognizance without John Howard supervision than with it. We're not setting them up for failure in that way. One of the positives of bail in recent years has been a move away from terms like not to possess drugs, not to consume drugs, not to possess alcohol, not to consume alcohol. I'm liking that we have a more therapeutic approach to those issues as well, which is intricately tied with mental health, as I've stated. But I encourage us all to push back on the other terms that could equally set us, our clients up for failure. And so, being observing the discipline of the household and observing the rules of the household, that term, it's so common that gets added in when there's a surety involved. But if you've got someone who is mentally ill and, the potential surety has they themselves talked about how difficult the person's behavior can be, are you just setting them up for tension and for the surety to essentially hold over that person's head? If you don't behave, what they're seeing as behavioral problems, which you kind of conceive more as mental health problems, well, then maybe that's not the best term. It might give the surety more feeling of security and feeling like they're in control, but is that necessarily a good thing when you've got mental health issues in the background? And so just really question and challenge each term that's coming along at you. And it's really, really, really easy and very, you almost want to just say, oh, I've got a release position on consent for my client. And you almost don't want to push back too much when that happens, but it's on the consent positions that we almost need to be more careful, because we don't want to just be rubber stamping the consent conditions that the Crown is asking for. Yes, you don't want to spend too much court time on a consent hearing if you can avoid it, but it could be the difference between your client being right back in custody a few days later if you don't, right? So those are my general comments about about bail rather, and how I'm kind of seeing things unfold in this new Zoom world and with mental health issues and everything else. So thanks.
Oh, great. Thank you, Cassandra. Okay, great. Well, it's been wonderful hearing, all these perspectives. More optimistic than I thought, actually. I mean, I know we talked about some things in our pre-interviews. So I'd encourage the audiences to type in questions into the Q&A. We've already answered quite a few from there. Yeah, I mean, the first kind of question I wanted to toss to the candidates has to do with accountability. In approaching bail, as a topic, I feel like it's one of these topics that you feel like has been studied to death. Like, people know where the problems are. They even know what institutional mechanisms would be useful. So, for example, like, charge screening to combat overcharging, or, some type of supervision of crowns to prevent unreasonable positions. And thirdly, accountability for JPs if JPs are not following the rule of law. So these are kind of like difficult problems in the sense that they're out of defense counsel's hands. Like, these are, police, crowns, and JPs. So I wanted to ask if people had thoughts about that and how that might get better.
Well, I'll jump in. I just bring a lot of bail reviews. I don't like to lose bail hearings when I think I should have won them. I get funding from legal aid. It's not enough, but they pay for the transcript. And I bail review just about everything that I think needs to be bail reviewed. It takes a ton of time, but that's what you got to do to serve your clients. In terms of accountability, though, the one thing you and I talked about before is, accountability in terms of the crowns and the positions they take. I think that is a difficult problem. Bail vetters tend to be senior crowns in their offices. And I don't think that there's a power structure in those offices where other crowns are going to call them out for the decisions they're making. And so I think the accountability has to come, like Cassandra has suggested, which is just defense counsel being vigorous in bail court and defending their clients and not worrying if it's a longer hearing than it needs to be, because the only way they're going to learn the lesson is if we get in there and teach it to them.
Great, thanks, Ian.
I think also reminding JPs that they can set the tone for a hearing is very important. So I'll often start my bail hearings where I know I have a crown who's about to try and read in, 2 hours worth of facts. Let's say you're in that situation. I'll say, Your Worship, I understand that my friend intends on reading in the facts. I've already told them that I consent to the materials having been filed, which I know your worship already has too. And so in keeping with her worship's directive, I would ask your worship to, or keeping with her honor's directive, sorry, I would ask your worship to consider giving the party some guidance here on whether or not you need to hear the facts. And then that really puts the ball in their court and avoids you sitting there listening for the next hour or whatever to the facts that otherwise everyone's read and knows about, right? And in the 1 or 2 cases where the JP hasn't had a chance to actually do the reading yet, then maybe you'll still have to sit there and listen anyways. But I think you're going to hear most JPs say, no, I don't need to hear those. Thank you very much, Ms. Donnell, right? So that's kind of been my way of also giving some power back to the JPs and almost encouraging them to use it because I don't know that they will unless you remind them that it's theirs to run, right?
Okay, thanks, Cassandra. Yeah.
Absolutely, I agree with everything that's been said, and I think to Ian's point and the point raised by others is that defense counsel needs to fight at bail. I was defense counsel for 10 years prior to coming to MAG. And I think, when you look at the studies that look at risk adversity in the justice system, part of that risk adversity lies, across the system, but also with defense. And it's not to a fault of their own. An accused person is at such a power imbalance when they're facing bail. And the reality is when someone's in custody, if there's an option put to them, being that if you agree to A, B, and C, we can get you released today, that is a very difficult thing to say no to, right? And so what we often see is Crowns asking for conditions that perhaps are not appropriate, that are over restrictive, and that position being relayed to the accused person who also ultimately has the decision to make. But there is a lot of advocacy that needs to happen between that, and I think really pushing the Crown on and the JP on every single condition that's being imposed is absolutely critical. With respect to accountability measures itself, the Crown Policy Manual, in addition to the directive of the Chief Justice, has a lot of good information in it. Whether or not it is all being followed is another question altogether. But having that resource, at your fingertips to be able to remind, perhaps Crowns that there are certain directives that they are required to follow by their ministry, I think also goes a long way. And I think to the point that has also been raised by others, is that, bail is not intended to change somebody's behavior. It is not about rehabilitation. Rehabilitation is not a principle at bail. And there is, I think, a certain paternalism that goes throughout the justice system where people see someone come before the system charged who clearly has issues that are perhaps not pro-social in their lives, that are perhaps not healthy. But the reality is bail is not there to try to fix them. It's not there to try to rehabilitate them. It's not there to try to force them to be, somebody's version of an ideal citizen or of a pro-social person. Bail is there to only impose conditions that are absolutely necessary in light of the three considerations at bail. And so I think we really need to push back against any types of conditions that really are, in essence, rehabilitative conditions where the court is trying to deal with a person's issue at the bail stage, which is entirely improper.
Great, thank you, Danny.
I'll just briefly add, I think you have 2 lawyers here on this panel who show up for bail hearings, which is great, and a former criminal defense attorney who shows up for bail hearings, but that's not always the case. And so completely echo the point about pushing and fighting against these conditions, but it's not always easy when you have, 10, 15, 20 bail hearings to run, and your JP says, we are shutting down court at 5 p.m. So as many bail hearings that you can get in, you can get in. If not, we're going to remand everybody to the next day. So I think that it's easier said than done, especially when you're duty counsel and maybe there isn't the sort of space or the grace to hear your submissions, or think that you're wasting court's time by making the same submissions for each individual. So for me, I think that we really need to pour some resources into duty counsel offices. We need to pour some resources into bail reviews. We need to pour some more resources into bail de novos. And so, because at the end of the day, you can make the submissions. I've made submissions also, submissions that I think are completely non-radical, just foundationally based on the law, but somehow it's not a successful bail. What is my recourse? A bail review? As a duty counsel, you may not be in the best position to be able to do that. And so I think that there needs to be a sort of realigning of priorities. So giving duty counsels the power and the potential, the ability to sort of challenge some of these decisions especially when they have no foundation, from my perspective, in the rule of law.
I'll just add to that point just briefly. I don't know, I haven't looked in a while, but I think legal aid was paying us about $300 for bail hearings. And that's why a lot of private defense counsel don't do them. And yeah, pouring a lot more money into that so that you get defense counsel actually showing up and doing the bail hearings would be a big thing that could happen. Probably wouldn't cost that much money. And if you don't get that client released, we all know that they basically end up pleading guilty. So I mean, it's the most important stage of the case, and it is the least well-funded service through legal aid.
Great, thank you. Cassandra, did you want to jump in there?
Yeah, if I can add, I find that oftentimes I'm actually fighting against clerks and trial coordinators too. I feel, especially in COVID world, that they are so integral, and don't get me wrong, they're important to the functioning of our system, but they've really had to take a real step forward in their roles of almost being gatekeeper of time and what is being scheduled when, and the processes for doing that. And if there's one thing I think everybody knows, it's that COVID has been really heavy on additional processes that we have to follow, right? And so it's done because they're meant to, because they've been placed with the role of gatekeeper, but there's oftentimes that they're overstepping their role by saying, that's not going to work. You can't put it to that day because, there's already 3 bail hearings scheduled and we can't possibly get to 3 bail hearings. Well, if you've run a bail hearing one time in your life and sat in bail court, you know that 2 out of 3 of the scheduled bail hearings are probably flopping anyway, right? So it's pushing back and saying, no, I would like to still be scheduled for tomorrow, but if we're last on the list and all of the 3 others run, then that's fine. I'll take my chances on that, but I would still like to be added to tomorrow's list, right? And so it requires advocacy, even on those small things. If we're talking just procedural points, you feel like you're fighting with everybody on everything, but you need to do it, because otherwise your client will sit in custody for as long as you let them, because otherwise no one else is going to care. No one else will want to see your client get a bail hearing faster than you. So you have to push back.
Great. Thanks all for sharing your thoughts on that. The other kind of question I wanted to pose, maybe this is slightly opens up the conversation a little bit, is overusing the criminal justice system because we're not funding other systems or because of systemic problems elsewhere. So you mentioned homelessness, not having culturally appropriate alternatives to charges. So I was wondering if people could give some thought or share their thoughts on that.
I think that another reason why I'm optimistic about bail reform is because I think, more broadly speaking, there has been a lot of conversation about changing the way that we do criminal law, including bail, sentencing, including prison conditions. And it's optimistic that we're talking about not only defunding the police, but detasking the police, detasking certain organizations, and saying, well, maybe if for example, if we take youth bail or youth, well, the purpose is we have a separate criminal justice system for youth because we acknowledge that young people have a diminished level of moral blameworthiness. And so maybe this process isn't the best process, especially when we look at the YCJA or we look at the criminal code and see what the principles are. At Black, for example, we intervened at a case at the Court of Appeal, R. and Morris. It was a decision originally from, I think, Old City Hall from Justice Nakatsuru. And it talked about the importance of talking about the systemic anti-Black racism and how that impacts potentially the constrained choices of an individual who's facing, a Black individual who's facing criminal charges. And I think that although, the decision came down and we didn't necessarily get everything that we wanted, the importance and recognition of anti-Black racism, I think, is changing the conversation. We look at the Ontario Human Rights Commission reports on the disproportionate levels of anti-Black racism, police use of force. Even if you look at the CCLA has a report on it. John Howard actually just released a report on youth bail and the disproportionate levels young people spending custody, in particular Black youth and Indigenous youth. So I think that the paradigm is shifting and the conversations are shifting to think about what are we trying to achieve in our society, more broadly speaking, when we're talking about criminal justice and holding people accountable for the crimes and the things that they're alleged to have done. And are we doing that in the most meaningful way and in a non-discriminatory way? I'll just add, in John Howard's bail report, I think it's called Unequal Justice, they talked about the importance of thinking about young people and sort of using the youth example as a proxy to think about criminal justice reform more broadly speaking. And I think the youth example is a good one. Thinking about young people and thinking about how we treat young people, how court goes for young people, alternative forms to incarceration. I think that's where we need to start putting our energy in. That's not to say that we need to do the advocacy work that we talked about earlier in criminal law, not just at bail, but at sentencing throughout the whole process, because again, we all, you're right, we all know that ultimately people end up pleading guilty when they can't get out of jail. But I think when we think about it from a bird's eye view, I think that we're starting to contemplate all their other alternatives that still keep people accountable for their behavior, but don't necessarily rely on systems and institutions that have just worked to reify oppression, particularly for Black and Indigenous and other racialized communities.
Thank you, Farida. Does anyone want to jump in? Okay. I guess, Danny, maybe I'll just throw you a question. In our conversation, you talked about, or you had mentioned Indigenous people having their own programs that are not related to the criminal system, but they can be diverted into, or kind of encouraging that, or even, seeing that as part of a corrective justice of what the province owes Indigenous people.
Yeah, thanks, Avery. And it's sort of further to Farida's comments. I think, there are 58 Indigenous restorative justice programs in the province, and Indigenous restorative justice programs do reflect, a complete legal system. If you look at the colonial system, it has evolved over thousands of years, going back to the ancient Greek philosophers and Plato and John Locke and Hobbes, who came up with the social contract theory. All of these things. It's important to note that Indigenous people had their own legal systems, full legal systems that were just as complex and sophisticated, that had just as long of a history, evolving over thousands and thousands of years, which provides a different worldview of justice, right? We can't take for granted that what we see in the criminal code is some sort of objective or universal concept of justice. It is a form of justice that has developed very specifically, over those millennia. And so Indigenous restorative justice programs, reflect Indigenous worldviews of justice and provide alternative forms of justice that are much more meaningful to Indigenous people. And that's really what the Supreme Court of Canada notes in Gladue and in IPELI in cases before and after, is that the criminal justice system has failed Indigenous people, and I think the same can be said for other racialized people, because it has failed to reflect their worldviews and perspectives of justice, right? And so pre-charge diversion is one way that we can avoid involving the justice system at all, and this is where police officers exercise their discretion, where they have reasonable probable grounds to lay a charge, but they exercise their discretion in the public interest not to lay a charge, and to instead refer the matter to an Indigenous restorative justice program. The same can happen in a post-charge setting where the Crown has that discretion to divert a matter out of the justice system. But certainly, I think it's one way. I mean, it doesn't, speak directly to the bail issue, but in a way it does, because often what we see is that somebody charged with a relatively minor charge, which could be diverted, instead gets charged and goes through the criminal court process. They then have all of these conditions, whether it be through their undertaking or through recognizance, which they're at risk to being charged if they breach. And so somebody who starts out with a very minor charge may rack up several fail to comply charges because they're, again, technical in nature and generally not substantive charges themselves, and then end up in a place where they can't get bail, right? And that ultimately, leads to a guilty plea where there will eventually be a jail sentence. So certainly, I think the more that we can get out of the criminal justice system, back into the community, and I think this is true for many different communities, I think we'll be in a better place.
Great, thank you, Danny. So I just wanted to ask folks, were there any other audience questions? I see that we've been answering actually quite a few in the chat, but if someone wanted to address any of those, speaking, just let me know.
I couldn't figure out how to answer. There was one question about how many people are at the Kenora jail. The official capacity is 105, but it is always over capacity. In fact, they have often been 4 people to a cell, which means not only is there a person sleeping on the top bunk, on the bottom bunk, on the floor beside the bunk, but there's actually somebody sleeping underneath the bottom bunk when they have 4 to a cell. So it's quite a dire situation.
And Avery, if I can change course a little bit, and I mentioned this at another panel I did recently, and I was surprised to hear that people didn't actually know about it. But if you don't yet, one of the major reforms that came with COVID and bail was MAG and SolGen, which are 2 ministries. Anyway, their funding of ankle bracelets for people on bail. My office has had great success with that. I know that we're all about, this whole conversation has been about, making sure that terms are reasonable, but sometimes the reasonable term is a house arrest bail, and you need that ankle bracelet to convince maybe not just the Crown, but even your JP or judge that bail is reasonable in that circumstance. And so it used to be that it was radio frequency for anybody in Ontario or GPS ankle bracelets at certain jails. The radio frequency program has died out because of a shortage of the chips to run the bracelets. So it's basically a COVID supply and demand problem. But the GPS program still exists in some jails in Ontario, specifically Toronto. I know EMDC is now on that list, which is my local jail in London here. There's a few other big ones. And so ankle bracelet monitoring is another way that you can go. John Rafferty just put in the chat that ankle bracelets are in very short supply. Is the waiting list that you're experiencing current and with Safe Tracks? Because that's not my experience currently. I'll just see if you can answer me quickly here in the chat.
I'll actually just interrupt. Safe Tracks actually just got a new supply, I think, because there was a period where I was having trouble getting approval now, but I spoke to them the other day and they said they've got lots.
Yeah, that there was a point. I know that there was a point where they were in short supply, but that's not been the problem for a few weeks now. So if you need any more information about that, you can feel free to email me. I've been one of the touch points for CLA on this issue, so I'm happy to share the materials that we have.
Okay, so yeah, I mean, I think where I'd like to get the conversation next is is somewhat related to kind of public perceptions around bail. And I feel like this conversation has actually been more optimistic than I thought it might be. So, you know, I think when we zoom out, again, like zooming out, we talking about more funds for duty counsel, you know, improve prison conditions. I too feel like in some sense the conversation is changing, but in another sense, like nothing's changing at all with regards to funding, right? Like funding is getting significantly cut, and we're building new prisons. We're not fixing any problems with our current prisons. So I guess I just wanted to get these panelists' thoughts on this kind of public communication, because I feel like there's, on the one hand, we're having a detailed, you know, we're having maybe a better conversation about systemic racism and the legacy of colonialism, but on another side, it's completely disconnected from the real policy actions that are needed to make those changes.
Well,
yeah.
In absence of any other comments, I found myself developing the habit of just emailing reporters and getting them on the phone and lecturing them about the importance of bail and why they should be writing better stories about bail. And I've had one or two successes. I wouldn't take the full credit, but I've participated in one or two stories about it. And, you know, I think as a profession, we can't be afraid to speak up out of court in the same way, you know, subject to law society rules, of course, but speak up out of court the same way that we speak up in court. And when you got people like John Tory and Doug Ford rampaging around making just idiotic comments about bail and the bail system and who's getting released, you know, we need a public pushback. We gotta educate the public in whatever forum is available to us, because it is really the most important part of our justice system.
And Avery, you said this when we chatted a while ago to prep for today, but there seems to be an appetite for this type of conversation now amongst our general public more than there ever was in the past. I think more members of the public are getting these issues more and more. And that's just for a number of reasons. You know, the Black Lives Matter movement, defund the police movements, and then now Every Child Matter movements. You know, we're seeing more and more general public citizens getting these issues and being given news stories in a way that they can understand. And then if you link that for reporters into the bail system and why it's all intimately connected, it's a beautiful time right now to make some good news headlines if you have the ability and the power and the will to do it. So.
And just because Ian brought up reporters, I just wanted to do a quick pitch. Yesterday and in the morning, we had a session with 3 of Canadians' leading reporters on the criminal justice system. And it was for A2J week, and we're going to be posting it on social media within the next day. So I would just say, please tune into that. I feel like it actually uniquely speaks to defense counsel, and it talks about what the journalists would like to do more with defense counsel, but you know, they may have issues doing so. I mean, it's interesting to think of, you know, for me who has not practiced in criminal law, I don't mean to kind of like I don't mean to recommend anything specific, but I think it's an interesting way of thinking about it, that, you know, the obligation is also, the professional scope of your professional obligation also includes, you know, trying to get the public on board for reforming the system.
I'll just say quickly, you know, I think a lot of credit does have to go to Black Lives Matter in terms of the conversations that are being had today. And, you know, I don't know if 10 years ago, if we were having conversations about defunding we weren't having these conversations. We weren't talking about, we weren't having the conversations in the sense that it's a sort of mainstream conversation about the disproportional ways in which certain communities are subject to certain systems of power, not just, again, criminal justice, but the nexus, right? The connection between criminal justice and child protection and employment and human rights discrimination and housing, right? I think, you know, from my perspective, especially with our community and my community, there is a lot of conversation, a lot of knowledge sharing that I think is great and that I'm learning from myself every day. So I think that that's happening in the wake of what we're seeing globally in terms of police brutality and violence that certain communities are just disproportionately subject to. There is this conversation. And so it's to me, this sort of feeds into the optimism that I have.
Okay,
One issue that sort of continues to come up is risk aversion, right? It's not just within the justice system. I think it's something that there has been a trend towards increased risk aversion in society in general. And it's a very difficult issue to get through. Both, I think, the public perception, but also the sort of evolution of the law has been better at dealing with the concept of how do we reassess punishment, right? And Farida mentioned, like with the YCJA, we recognize that youth have a diminished moral culpability, and that can be understood, right? We can tell a story to explain why a young person is less blameworthy than perhaps an adult because of their situation. Similar to that, I mean, the application of Gladue principles and the potential expansion of those principles to other racialized groups fundamentally speaks to one's moral culpability, right? For Gladue, we understand that the legacy of colonialism and the intergenerational trauma caused by that legacy has affected people to the level where we can say they are less morally culpable and therefore less deserving of a lengthy jail sentence, for example. But the issue at bail is focused 100% on risk. And that has always been the challenge when it comes to, say, applying Gladue to bail. We know the criminal code now is quite clear that Gladue applies to bail, and the courts have said that for well over a decade in Ontario. But the issue becomes this: how do we apply it in a meaningful way? And so bail seems to be so focused in on risk. And I think the public perception is that there are very few tools to control risk. And I don't think that's borne out by the reality. I think in reality, there are a number of different ways to address risk. And those methods of addressing risk may look very different in one community or in one culture than another. And so I think we need to sort of really challenge our thought processes around risk. It's easier said than done, but I think there needs to be some focus on that.
Yeah, I'd just like to double down on that point and say, I have done lots of bails. I have raised Gladue issues in bails. And the danger in talking about a diminished moral sort of sense of moral responsibility is the bail hearing turns into, how can we fix this accused person? And then you wind up with this bonkers bail with conditions that should never be in a bail because the JP decides that they're going to tinker with this person's life. And I think that alternate approach, which is to say, it's not so much about the accused, but it's about there are other resources in the communities, in the families. Not every bail has to look like a white middle class living in your mom's basement kind of bail. There are other ways to manage the risk, and you have to sort of look across cultures and find them to get people out on bail. And that's the discussion that needs to be had. Otherwise, we wind up with just terrible bails that people can't follow and that are frankly unconstitutional.
Thanks. Oh, sorry, go ahead, Cassandra.
I'm going to just put in the group chat one of my favorite cases of recent times, Regina and Mustard, which is a murder case where it was a homeless person and the council got him bail on his own recognizance. So talking about Ian's idea of, it doesn't have to be your typical bail plan. It's one of my favorites to just really encourage you to think outside the box, because I remember reading that case and it will forever stick out to me as the holy, what moment of bail.
Great, thanks. So it's about 4:10. We don't have that much time left. I'm going to kind of throw a wrench a little bit. I don't expect everyone to answer right away, but I did last year when we had a similar conversation with Promise, actually, she was on the panel last year, she mentioned the third ground of bail and using that as a way to basically to flip the script of the third ground, right? By saying, you know, does it shock the conscience of the public to have these extremely onerous conditions on an Indigenous person or a Black person? And I recently saw a law Twitter, people are talking about this. So I don't know whether this is like, you know, too creative in a sense, but Danny, you'd mentioned like, how do you really bring up these things, you know, Gladue factors, and it seems like a different way to do that. So I was kind of curious if anyone had thoughts about that.
I use that argument all the time. I mean, it's essentially one thing that I raise all the time is, you know, that if you detain this person, they're going to be in custody for a year or 2 years, and the sentence they're looking at might be 6 months if they were convicted after trial. And so if you detain them today, I'm just going to get them out on a bail review 4 months from now on reasonable conditions. And so it's not reasonable to detain them today, because and that is essentially the argument. It's actually been around longer than the recent tertiary ground. And the case is, I'm drawing a blank on the case name right now, but basically when the person is detained past time served, it would shock the conscience of the public. It would be an injustice to have somebody in jail longer than a fit sentence, and you got to let them out. And the case law says you got to let them out on whatever crappy plan they can come up with. And so you have to challenge justices to just say, you know, maybe that plan is good enough today.
Great, thanks, Ian. Does anyone else want to hop in as our last comment? No? Okay, well, that's okay. So in the interest of not cutting anyone off, you know, in mid-sentence, I'll wrap up now then.
It's RV White, by the way.
RV White, okay.
Cassandra White.
Thanks.
I'll post the link.
Okay, thank you. I'll just type out here. Yeah, so we had 100 people register, and we have 50 participants stay throughout. Rainy, at least over here, rainy Friday afternoon. So, you know, we're really grateful for everyone's time and attention. I really want to thank the panelists again for sharing their expertise and insights. Like I said, I feel like we ended up having a more optimistic event than I thought, which is good. Please follow everyone on social media. I feel at least a few of you have social media accounts. And our social media account is Law Design Collab on Twitter and Instagram. Okay, so this is our last event for A2J Week. So thank you again to the Law Society for enabling us to put this event on. Okay, well, everyone have a great weekend, and, you know, I hope we can continue this conversation and others like it in the future.
Great, thank you very much.
Thank you.
Thanks, bye everyone.
Everyone.
Bye.
Thanks.
Bye.